Hello everyone, welcome to the 170 Literary and Jury Charge. I'm going to start off with a small segment from Don't Sweat the Small Stuff. And this is called Ask Yourself the Question, Will This Matter a Year from Now? Ready? Almost every day I play a game with myself that I call Time Warp. I made it up in response to my consistent belief that what I was all worked up about was really important. To play Time Warp, all you have to do is imagine that whatever circumstance you are dealing with isn't happening right now, but a year from now. Then simply ask yourself, is this situation really as important as I'm making it out to be? Once in a great while it may be, but a vast majority of the time it simply isn't. Whether it be an argument with your spouse, child, boss, or a mistake, a lost opportunity, a lost wallet, a work-related rejection, or a sprained ankle, chances are a year from now you aren't even going to care. It will be one more irrelevant detail in your life. While this simple game won't solve all of your problems, it will give you an enormous amount of needed perspective. I found myself laughing at things that I used to take far too seriously. Now, rather than using up my energy feeling angry and overwhelmed, I can use it instead on spending time with my wife and children or engaging in creative thinking. Great advice there. Got some jury charge. Here we go. Ready? They were asked to state the name and address of any person who is a registered owner of the motor vehicle you were driving as of the date of the accident described in the plaintiff's complaint. Both individual defendants at that time, May 5, 2005, stated under oath Davis Sales Company in Webb City, Missouri. As well, just to cover any loopholes that might have been available to the defendants at a later date, I then asked the following question. As of the date of the complaint, if any person or company other than those persons who were named in the answer to the question, Davis Sales Company, had any legal ownership interest in the motor vehicle, please state the names and addresses of such persons and what interest they had in the ownership of the vehicle. I asked them whatever legal ownership interest, and that covers any sort of ownership that you can have in a piece of property, such as an automobile, and both individual defendants answered under oath, none. There is nobody else. So at least we know as of May 5, 2005, the individual defendant's version of the fact of ownership of the motor vehicle was under oath that Davis Sales Company was the owner of the vehicle at the time of the collision. We now come to a trial, and the defendants and the father of the young defendant take the stand and testify under oath that the title had been signed away prior to the collision, which is somewhat of a different version of the facts, totally different. So it is for you to decide how to determine the conflicts in the evidence. At which time were the defendants telling the truth? Was it on May 5, 2005, when they both swore under oath that the Davis Sales Company owned the car at the time of the collision? Or do you believe that now under oath, where they say Davis Sales did not, that it had been conveyed to John Davis? The only other piece of evidence concerning the ownership of the vehicle will go back again to Plaintiff's Exhibit Number 9 and look to an affidavit under oath for title for a new license plate. It is signed by Davis Sales Company by Sonia Davis, which, as you know, was the wife of Gene Davis, who says it was the agent of Davis Sales Company. And it says under oath that the owner's name is Davis Sales Company. You will note by this that this was applied for and sworn to on July 11, 2005. And you will also note that another title was issued, and it again is in, and it was issued right after the application. Now, how do the defendants expect us to believe their version of the facts at this time? Yesterday they told us, I do not know. I can give you my understanding of their testimony. They testified, from what I heard, that the title was signed and mailed by Gene Davis as the agent for Davis Sales and given to the son, sent to the son here in Tampa, Florida, sometime before the collision. The boy had the title until sometime after the collision, and then he drove back to Webb City, Missouri, and in the middle of the trip between West Palm Beach, Florida and Missouri, the title disappeared. The title was contained with important papers and clothing and personal items in the trunk of the car, and when he arrived in Missouri, it was gone. No one or no explanation is offered by the defendants for the disappearance of the title. I asked each one of them. I said, did you have an accident on the way back, or have a fire, or was your car vandalized? What explanation can you give this jury to explain that mysterious disappearance of this title certificate? And the defendants offered none whatsoever. Okay, I've got a story here called Tears of Joy. Ready? And it's going to start off with Lucille Ball, a quote from Lucille Ball saying, love yourself first and everything else falls into line. You really have to love yourself to get anything done in this world. Here we go. Ready? To cry is uniquely human, to weep for joy even more so. I cry every day. I cry for all the years I wanted and needed to cry and didn't. I cry for the loneliness and pain I felt. I cry for the sheer delight of being alive. I cry for the pleasure that moving my body brings and for the ability to dance and stretch and sweat. I cry in gratitude for the life I have now. I was a cute little girl. I loved laughing and playing with my friends. Then, when I was 8 years old, I experienced a trauma in my life. In order to cope with that physical, mental, and emotional nightmare, I made 2 unconscious decisions. First, I wanted to be as ugly as possible. Second, I didn't want to think or feel. I knew if I let myself feel anything, it would be too much for me. So, I started eating. When the fear came, I ate. When the pain came, I ate. By the time I was 12, I weighed 200 pounds. I spent most of my time by myself doing things with my hands or watching TV. Even with my brothers and sisters, I felt alone. I was never asked out to a dance or to a movie or on a date. I was socially invisible. By the time I was 25, I weighed 420 pounds. My doctor gave me 6 months to live. My body couldn't support the fat I was carrying. I didn't leave my house for 2 years. I literally couldn't move. I had to lose the weight if I wanted to live, and I decided I would do whatever the doctor told me to do to lose it. I lost my first 100 pounds, and I felt so light I wanted to dance, but I started to gain it back, and I realized I had to go deeper and deal with the root of my problem, the unfelt pain. I began therapy, joined a 12-step program, and accepted the love and support of my family and friends. At 35, I cried for the first time since I was 8. Feeling my pain was the true secret of my weight loss. Once I turned that corner, it was up to me to continue the work and to be conscious one day at a time. It was a process of growing self-knowledge and self-acceptance. I continued my therapy. I started to study nutrition, and I learned that for me, eating fat is a sedative. I watched my behavior and monitored what brought on my need to eat. When I found myself knee-deep in Haagen-Dazs, I stopped and asked myself how I got there. Though there were times when I would backslide, it was my acceptance of myself in all my strengths and weaknesses that helped me get back up and keep going. My goal was to be better, not perfect. When I see childhood obesity now, it breaks my heart. We wouldn't dream of laughing at a child who has no arm or leg or who uses a wheelchair, but people will tease and ostracize a child who has an eating disorder and is obese. We still don't understand that the weight such a child carries when the weight of that child's own pain. Healing my life wasn't just about losing weight. I had to learn how to live life as an adult. I had never learned basic social skills. Once at work, a man talked to me at the water cooler, and I giggled like a 14-year-old girl. I started the process of learning about relationships and growing up. Now at 46, I am an adult. I have become a person I truly love. My weight is in the average range. I exercise regularly, and I have a career I love as a motivational speaker. I recognize the good things that come from my years of childhood pain and isolation, my love for classical music, my ability to sew and to do stained glass, to create beauty with my hands. Even my ability to speak well and engagingly can be traced to the many hours I spent watching such great entertainers such as Lucille Ball, Will Ferrell, and Adam Sandler on TV. I am grateful for the blessings in my life now, and I accept the events in my life as gifts of growth that create strength of character and strength of faith. Today I cry in gratitude for the life that I have. Okay, go back to some jury charge. Ready? Those things, as I say, I think are set by the stipulated facts. I think they will be clearly brought out by the facts to be shown at trial. The other facts that will be shown at trial are the existence of a partnership between Cora Carr and Randy Cope. There will be a partnership agreement dated December 11, 2010. It's Exhibit 30. It will come in at trial. It's in Randy Cope's handwriting. She will testify to it. There is a second agreement that the parties will testify that all of their acts, which each of them took with regard to the subject property, were taken on behalf of the partnership, that neither of them took any individual actions with regard to the property. There will be a second agreement, which is Exhibit 44, which will come in. That agreement, which was typed by Randy Cope, signed by Cora Carr and Wayne Cope, is on December 30. It reaffirms that the subject property is held by the partnership. Now there is an issue that the court has been made aware of through a pre-trial motion, and that is whether or not a deed which was signed by Randy Cope ended the partnership. The evidence that will come in on that issue is that on or about December 5 of year 2010, Randy got a phone call that her father, who lived in Norway, was stricken with cancer and was going to have major surgery on the 13th, that she immediately made plans to go to Norway, did not know how long she would be gone or whether or not she would return. She's a resident, a native of Norway, and didn't know what the family situation would be when she got there. The evidence will show that she then wrote the deeds to Cora Carr on a phone number of properties, on a number of properties on which they were partners. She gave those deeds to her with the understanding that if something happened while she was in Norway, if she died or she didn't come back, you are authorized to use these deeds. If she came back, you will give them back to her. Randy came back in January of 2011. The evidence will show that Cora Carr immediately returned the deeds to her, and the evidence will show that the deeds were never recorded and they remained in Randy Cope's possession until the filing of this case. The evidence will also show that neither Cora Carr nor Randy Cope treated the deed as ending the partnership. That wasn't their intent. That wasn't their belief. That wasn't why it was given. The evidence will show it was given as a device in the event Randy withheld any harm or died in Norway. So we have the partnership agreement in 2010. We have the deed in 2011, which I think the evidence will show was not a transfer. But I know the defense will say it was. We have an agreement which recognized the partnership. And we have the parties' testimony that they did all their acts on behalf of the partnership. I don't think there are any things in this case which are not set either by the facts or by the evidence that will come in. As I said, I think the facts establish the existence of open, continuous, adverse, and hostile possession for a period of time, which was when the payment of taxes occur through today, which is 3 years. And I don't think there's any defense to this case. I think the evidence will show that. All right. A few more minutes here. I've got some congressional record, and this is called Men's Only Clubs. Ready? Mr. Gable, Mr. President, I think the senator from Iowa, I wholeheartedly agree on his last point. One of the greatest losses to the United States is that women have not been active enough in our economy. Business Week magazine recently conducted a study. Out of a total of 5,000 top paid individuals in big business in this country were women. Of those 22 women, 15 were positions of responsibility because they were the wife or daughter of the chairman of the board. Doesn't it appear that women have never been given a chance? Until just recently, some of the Eastern schools were classified as men-only colleges. This is ridiculous. Were they implying that women are less intelligent than their male counterparts? We should not only encourage women to seek equal chances, we should also enable them to get an equal chance. Women are beginning to get into the top law schools and the top medical schools, but it is a slow process. We, as members of Congress, should certainly do our best to discourage exclusive memberships in clubs for men only. If women are excluded, this is a form of social and economic discrimination. The problem we are faced with is evaluating the position of Paul Lang Taylor, who has adapted a posture of defense for the right to all male social clubs which exclude women. I wonder if Mr. Taylor understands the discrimination that is involved in this issue. A social club is organized to conduct business, social, and community activities. If women are excluded, Mr. Taylor is inferring that they have no business conducting these activities in conjunction with their male counterparts. I do not agree with Mr. Taylor's point of view, and I would like him to present to this committee in writing a justification of his position. Okay. I've got some legal opinion here. Ready? We must determine if diminished capacity existed. A careful examination of the evidence and all the intervening circumstances is necessary. If you find from the evidence at hand that at the time of the alleged crime, the defendant, Clark Pearson, had substantially reduced mental capacity, whether it was caused by mental illness, mental defect, intoxication, drugs, or any other cause, you must consider what effect, if there was any, this diminished capacity had on Clark Pearson's ability to form any of these specific mental states that are necessary elements of murder and voluntary manslaughter. If you do find that Clark Pearson's mental capacity was diminished to any extent, where you have a reasonable doubt whether he did, maturely and reasonably, premeditate or deliberate, and consciously reflect upon the gravity of the contemplated act or form and intent to kill, you cannot find him guilty of deliberate and premeditated murder in the first degree. Therefore, if you do find that the defendant's mental capacity was diminished to the extent that you have even the slightest reasonable doubt whether he was able to form the mental states constituting either express or implied malice aforethought, you cannot find him guilty of murder of either the first or second degree. Furthermore, if you have any reasonable doubt whether he was able to form an intention unlawfully to kill a human being, or as to whether he was aware of the laws of society imposed on him not to commit acts which involve the risk of grave bodily injury or death, or whether he did act despite that awareness, you cannot find that he harbored and expressed malice. Furthermore, if you have a reasonable doubt whether Mr. Pearson's acts were done for an obvious antisocial purpose, or whether he was aware of the duty society imposes on him not to commit acts which involve the risk of grave bodily injury or death, or whether he did act despite this awareness, you cannot find that he harbored an unqualified implied malice. If you find that as a result of any mental illness, mental defect, drugs, or intoxication, Mr. Pearson's mental capacity was diminished to the extent that he neither harbored a malice aforethought nor had an intent to kill at the time the alleged crime was committed, then either murder or voluntary manslaughter is not a possibility. Okay, that concludes our literary and jury charge for the 170 class. Have a great day.